Hello and welcome to Between Parks Place and Capitol Hill, the Six News program all about law and government in Australia. I'm your host, Steward Jeffrey, GovCheck editor, and joining me is parliamentary reporter Aidan Edgecombe. The focus here is, of course, on the recent migration cases, Ben Breer and Minister for Home Affairs, Jones and Commonwealth, and now NZYQ is the latest one to come out. We've just received the judgment a few days ago at the time of recording. We had recorded this beforehand, and I actually said to Aidan, nah, look, we're not going to get a judgment until next year. And then literally the next day, we get the High Court saying, we'll release it tomorrow. So this is our second time recording this. Of course, we do now have the reasons, so we will be spending a lot of time looking at those reasons, but it's not the first case. NZYQ, while important, especially because of the child sexual offences involved, there isn't that big in and of itself. It's taken in the broader context of Ben Breer and of Jones. So I might get you to start off, and just what is the importance of Ben Breer here, because it's the first of the three cases that we have to deal with.
So Ben Breer is essentially clarifying the fact that the executive government, so a minister, can't strip the citizenship of someone as a punitive measure, in other words, as a punishment. So the case Ben Breer regarded a man who was convicted of terrorism offences, which made it a hot political issue. But from a legal perspective, he was charged with crimes. He served his time and is still serving time in jail for those crimes and had his citizenship stripped because of this. And Ben Breer, the case, found that this was unlawful, given that the executive government can't be punishing people for crimes they commit. The courts, the judicial branch of government is able to, but not the executive. Of course, this is relating to the separation of powers, and we'll get into that much later. But essentially, the executive government was unable to strip his citizenship, and it was put just to the role of the court to do so. The exception to this was Jones versus Commonwealth, which you mentioned briefly, Stewart, which clarifies again an exception from Breer that citizenship can be stripped if the crimes in question were committed before the person became a citizen. So if you commit crimes of terrorism or whatever it may be, and then are granted citizenship after you committed those crimes, the executive branch of government can strip you of your citizenship.
Of course, and the issue here, you're correct, is with separation of power. With Ben Breer, so we don't have true separation of power in Australia, like in the US sense, but we also don't have what we call parliamentary sovereignty, which is what they have in the UK with the Westminster system. Our courts are strictly independent because the Constitution has 3 chapters. Though it has more than 3, but the first 3 talk about the legislative and then looking at the executive and the courts. And so the way that it's been interpreted is that there are therefore 3 different branches of government, the courts being a distinct branch of government, different from the executive and legislative, which kind of overlap because all the ministers and the prime minister are drawn from parliament. So the way this works is that the court has said in the case of Ben Breer that, the punitive powers are exclusively the job of the courts. So it's basically double jeopardy in one aspect. Of course, the court didn't describe it that way, but it's similar to double jeopardy in that the court's meant to punish someone. You kind of the executive going, nah, we're going to put you in detention as well, just for the exact same crime. And of course, the government's going to try and change that right now, which we'll get to shortly. However, in Jones, of course, the difference is that Section 51 of the Constitution gives Parliament certain powers on what it can create laws on, and one of those powers is the aliens power. Not UFO aliens, foreigners, non-citizens. So in that sense, the court's gone, separation of powers exists, but because the Constitution gives the government exclusive authority over this, or because it gives Parliament exclusive authority, we can't do anything because the Constitution says otherwise.
The separation of powers at the federal level between the executive, legislative, and judicial, this doesn't quite exist the same way at a state level. Obviously, being a separate jurisdiction, there are different sort of rights granted to state governments, and parliamentary sovereignty, which you mentioned briefly earlier, is emphasized a lot more at a state level. I've talked about this in an article I wrote about the Victorian Greens proposing a constitutional change. And of course, federally, to change the Australian Constitution, the only way to do so is a referendum. But state constitutions are given authority under Acts of Parliament, and in most cases can be amended through Acts of Parliament. It doesn't need to go to a referendum of the people, and this gives the government a lot more will to be able to legislate on these issues.
And of course, this gives rise to a great debate between separation of powers and the Westminster system, and it is one we have seen in the High Court in recent years. Most recently, Garrett from last year, Garrett in Western Australia, which was generally seen by the legal community as a serious erosion of the cable doctrine, which said, okay, state Supreme Courts, they have federal power, therefore they should be independent. State parliaments can't tell them what to do. They're going to be a bit more independent. In Garrett, the High Court said, yeah, but no. It was basically the High Court. The High Court said, yeah, well, state governments can determine, when and how this should be applied. They gave them a lot more scope in how to use these powers. In that case, it was something as simple as an aggravated robbery, which in that case was $20, I believe, and a necklace, and that was sufficient to then put in place a protection order to keep Garrett in prison for a longer period of time. However, in that case, we saw strong dissents from now Chief Justice Gagler and also from Justice Gordon, and a kind of dissent from Justice Edelman, who had different reasons to the majority, which at the time included Chief Justice Kiefel, who was since retired, and Justice Keane and Justice Steward, who is still on the bench. So we do have this ongoing struggle, which we have seen in Ben Breer and in Jones, where we have dissent from Steward, who is probably the strongest defender of parliamentary sovereignty on the High Court right now. Going into Ben Breer, I had said we're going to see a dissent from Steward again. However, we saw a unanimous judgment from the High Court, and that included Steward agreeing with the rest of the court on this issue, which said that, okay, we draw a line in the sand here. You cannot detain asylum seekers indefinitely if there is no reasonable chance that they can be deported overseas. And of course, the important thing here is reasonable chance. The High Court had said previously, absolute chance.
Yeah, the reasonable chance, that sort of distinction is very important here, because it involves the issue of proportionality, whether something is a proportionate response to a certain issue. You can't just do something that you have an issue that has certain implications. You can't have a major overbearing response to that issue purely because of, say, one area. It has to be proportionate to the actual issue at hand. And as you say in NZYQ, the response, the judgment wasn't unanimous, but Justice Edelman did have his separate reasons for the judgment, and this heavily involves proportionality, whether something is reasonable. And again, it mentions in the specific case of NZYQ, the possibility of the plaintiff, of the offender of the sexual assault cases being relocated to the US. Now, in Al-Kateb, a previous case, it was found that indefinite detention is lawful, and even if the prospect of deportation is incredibly thin, as long as it does exist in a way, the person can be detained. Now, this was then overturned by NZYQ with the strong emphasis on proportionality, whether there's a reasonable possibility of deportation, and it was heard in the court that it was possible that the plaintiff could be deported to America, or could be relocated, to America, but this wasn't reasonable in the foreseeable future. And this was sort of the difference between Edelman's reasons to the rest of the majority, with the strong emphasis placed on, is the response proportionate?
It's okay. Proportionality is definitely, so we've seen long-time readers of the Commonwealth Knowledge series will know that I've probably like half a dozen articles now on what's called the implied freedom of political communication, which is the closest thing we have to free speech, although it's no longer referred to as free speech. It's more of a equal opportunity to engage in politics in Australia as part of the fundamental nature of democracy, where people have to have a say, which is why we vote. And of course, to be able to vote, you have to be able to have the conversation about political issues. And because there's a proportionality test devised there, which says, okay, you know, at what point can we limit speech? For example, with protesting, we saw a lot of protests during COVID, whether it be anti-lockdown protests or Black Lives Matter protests. The court saying that's not a reasonable use of the implied freedom because of the health implications there. However, we have also seen at Brown in Tasmania, for example, they have said, okay, the response to protests here is disproportionate. We need to strike down these laws. So proportionality, again, it's something that Justice Edelman is well known for advocating. In Garrett, for example, I mentioned that he kind of agreed, kind of didn't agree. He gave his own reasons, which was based on proportionality. In that case, he said that it was in giving the parliament that power, it was okay, but it was perilously close to not being okay. If it had have gone a little bit further and given the parliament a little bit more sovereignty, he would have drawn a line in the sand there. And of course, this proportionality is kind of similar, but also different to the reasonable test, which we have now for the chance of being deported. Alcatel, of course, as you mentioned, Alcatel and Gordon, it's from 2004. We had a 3-4 split on the High Court, 4-3 split for upholding legislation under John Howard, which said that there must be an absolute chance that they cannot be deported in order for the detention to be unlawful. Among the dissenters in that case was of course Justice Michael Kirby, who was known for his dissents. It's him and Justice Hayden who are probably the two biggest dissenters in the High Court's history. And so now we've seen the court respond to that and say, well, unanimously, it's now only a reasonable chance, because there's always a remote possibility that they could be deported. However, the High Court has said, yes, it's a reasonable chance. But if the situation changes and the laws change and it now becomes reasonable that they can be deported, you can put them back in detention. So it's only while there's no reasonable chance, but if a chance arises, they can then be put back in detention. So that's a key difference there is they didn't say that there was, you know, it was absolutely, they didn't say there was, they were free forever. They said if there becomes a chance where they could be deported and it is a reasonable chance, then okay, you put them back in detention until that opportunity passes or until they do actually get deported. If that then becomes no longer likely, they get released again. However, the important thing here to mention is that these people who have committed crimes, which is why they've had their visa stripped, the court said, yep, but they're still going to face the exact same punishments as everyone else. Just because they can't be held in detention doesn't mean they're exempt from criminal law in Australia.
That's exactly right. And just want to touch on that last thing you mentioned of the Australian law applies to them just as much as any other citizen of Australia, which, as you say, means that they can be re-detained if there is a reasonable chance of deportation. But more importantly, that the implications of cases like Garrett, which allow people to be continuously detained continuously imprisoned, because of a serious risk of reoffending and an impact to community safety. This can still apply to the people affected by NZYQ, and Edelman himself, Justice Edelman, mentioned this, saying that if there is a reasonable risk of reoffending and it does pose a threat to community safety, someone can very easily continue to be imprisoned in the same way that any other citizen of Australia can be. Touching back to Ben Breer quickly, this was also important in that obviously his citizenship can't be removed, but the Attorney General is likely to apply for his imprisonment to continue to exist even after his sentence ends. So this whole idea of, yes, they can't be indefinitely detained if there isn't a reasonable, or it's indefinite, if there isn't a reasonable chance for deportation, they can't be indefinitely detained. But they do still face the same requirements under the law as any other Australian citizen. And this is, I suppose, where the political pressure starts to come in terms of, well, what criteria is gonna be involved in terms of their release, because I believe one of the people who has been released from indefinite detention has now been charged with other offences. So in terms of the community safety aspect, there's a lot of political pressure on the government to keep, the tagline is to keep the community safe.
NZYQ, or a situation where, yes, it was unanimous, but it actually wasn't unanimous. All 7 judges came to vote together. However, there were actually 3 camps. And this is a very cumbersome ruling, because normally what you'd have is the core group here is Justice Steward, Justice Beach Jones, Justice Gordon, and Chief Justice Gager, and they form the core judgment. Normally, what you'd see is them doing a what we call majority judgment, where the 4 of them are a majority of the court. They'd write a judgment, and then the other judges would say they agree, but in this case, Justices Gleeson and Jaggett actually hadn't decided when they gave the judgment, which is why Chief Justice Gager said at least a majority of the court, because Justices Gleeson and Jaggett hadn't actually made up their minds at the time. They've since decided, yeah, it's unlawful. But what you would normally see is you'd see those 2 justices say, well, we don't know if they both disagreed for the same reasons or if it was differently, but we'd see them usually say, I concur with the rulings of the majority. And that's it, but noting that they aren't part of the majority in and of themselves, they're just agreeing with it. And then you see Justice Edelman, who gave his own judgment on proportionality, but he gave it as part of the majority's judgment. You'd see him saying, I agree with the majority on most of what they said, except for on these points. Very annoyingly, we've now got one big judgment, so it's hard to work out what the exact reasoning is, because we don't know what the concerns of Justices Gleeson and Jaggett were, and we don't know, and we don't have a full explanation from Edelman on why he wrote differently. So it is going to be a bit difficult. It's easier than Uncle Ted, where you had each judge giving their own judgment, but we do have a cumbersome judgment now. It's going to be hard to work out exactly how each judge fell, especially again because Beach Jones is an unknown. He's been in the High Court for less than a month at the time of recording, at least. About a month, so we don't know which way he will fall. Jaggett, again, is pretty unclear, because Garrett was before her time. She, of course, replaced Justice Keane shortly after Garrett was handed down, so we don't know all the details about how the court will fall on that, but it is likely that it will be challenged. Given how controversial it is, it will be passed by Liberals and Labor, because it is based on previous Liberal laws. And the Liberals have actually said they're not going to decide until the 7th. We're recording this on the 6th. They won't decide until the 7th on how they want to fall on the case, but they've given it support in the Senate already. So it's passed the Senate. It's now back to the House of Reps, where Labor has a majority, and Labor MPs can't dissent against the rest of the party. So it will end up passing, because Liberals backed it in the Senate. So it will become law. We could see a challenge in the new year. However, it does form part of the broader context we have of parliamentary sovereignty versus separation of powers.
Yeah, the whole debate regarding parliamentary sovereignty and separation of powers, it's not a new topic, whilst it's certainly heating up in the light of NZYQ and the light of Ben Breer especially. It's been around for quite a while. The example that I'll bring to light is the external affairs power in the Australian Constitution. Now, what it does is, I believe part of Section 51 gives the government, the Commonwealth government, the right to legislate on external affairs, which is in other words foreign affairs, things that are going to impact our relationship with other nations. Now, this is the most common interpretation of this, or at least when it has been used, is in regarding to United Nations agreements or conventions. Now, this was seen, of course, in the Tasmanian Dams case, where Australia signing and ratifying the UN Convention into law, it provides some sort of expectation that we will follow through with that. And what it did find is that if we didn't do so, it could have potential to impact our external affairs with other countries. But this is a major proponent of parliamentary sovereignty, because, of course, when the Constitution was written, the United Nations didn't exist. It hadn't formed until after World War II. So what it does, and by the court affirming, laws in relation to UN conventions, what it does is it allows the parliament more freedom to decide what matters are going to impact our external affairs. And though the United Nations is perhaps the biggest way we've seen this done, this isn't specifically outlined under the Constitution. It's only referring to a judgment or a decision from the Parliament that, hey, this is going to impact our standing with other countries. We've got an international mandate or an international agreement to do something, so we're going to make sure we do this. And that is parliamentary sovereignty. It's giving the Parliament the right to do that.
There's actually a fight between Chu Kang Lim and Al-Khatib, which is the 2004 case. And confusingly, the High Court has said, okay, well, Al-Khatib's been around for, at this point, 19 years, and no one's ever tried to challenge it. No one's tried to ever overturn it properly. There's been some discussion of overturning it, but it's never actually been overturned. And that's because it is an accepted part of the law. But at the same time, the High Court's gone, it's an outlier. The actual way they use this is an outlier, that somehow it's an outlier. And I personally, I don't get how it can be both an outlier, but also a part of law that's so concrete that it hasn't been challenged for 2 decades. But we are seeing it. Dr. Joe McIntyre actually referred to this, and I'm going to borrow his term there, age of limb. Going through the judgment, the High Court referred to Chapter 3. Of course, Chu Kang Lim draws its basis from Chapter 3, separation of powers. Again, punitive measures are the job of the courts, not the executive. So the High Court here has referred to Chapter 3, which is the basis for the separation of powers, 17 times, or 16 or 17 times. They referred to Chu Kang Lim 36 times, and that's only including footnotes. It'd be about 40 if you include footnote references there. So more than double the references to Lim rather than to Chapter 3. And this isn't the best idea, because the risk here is if they somehow strike down Chu Kang Lim, which is very unlikely, especially with Gageler as Chief Justice, potentially after he retires, which is not going to be for a few years yet, is that basing everything on Chu Kang Lim is kind of putting all your eggs in one basket in a legal sense. If Chu Kang Lim gets overturned, then everything else is pretty much overturned as well. This is a concern that I've raised with a few other people about this judgment, is that it does probably rely a bit too much on Chu Kang Lim rather than Chapter 3. There is some reference to Chapter 3. For example, Justice Edelman said Chapter 3 of the Constitution extends beyond those classical criminal notions of punishment based upon just desert to another analogous instances of protective punishment. That's kind of, it's very, 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 very complex, but the next sentence shines a lot more light on it, and the purpose of a law which is concerned with executive punishment in this sense would be illegitimate with regards to what we have right now. So it very much is still about executive punishment, and when it is illegitimate, and that's probably one of the better descriptions of Chapter 3 we have here, in that that's Chapter 3 and the Lim have the exact same focus. And so His Honor actually goes to deal with that, and although again to draw from the exact same judgment, the approach of Edelman J is slightly different, although perhaps only because it disaggregates the concept of punishment as used in Lim. And that's exactly the point here, is that Justice Edelman was trying to make the point that, Chapter 3 is more important than Lim. It is the age of Lim, in that we are relying more on case law for separation of powers than the Constitution itself. And you do then run the risk of, you've got cases like Al-Khatib, which back up parliamentary sovereignty, cases like Chu Kang Lim, and now NZYQ and Ben Breer, which back separation of powers. And it ends up becoming a battle of common law against common law rather than constitutional law. It does kind of distract from the overlying principles in the Constitution by relying on case law. However, fingers crossed, it does change. We could see a challenge to the new legislation that we are seeing from Parliament, but that's not going to be decided until next year. Hopefully, we see the court move towards Chapter 3 more than just relying on Chu Kang Lim, because again, all your eggs in one basket. It's not a unanimous judgment. I know that there are others who disagree with me, who do think that Chu Kang Lim is an important case. It is kind of basically a synonym of Chapter 3. So the question is whether it is the same as, or whether it draws from Chapter 3. But at least in my opinion, and I try not to get political about this, but at least in my opinion, we do see a bit too much of a reliance on Lim in this case. A bit more discussion of Chapter 3 would be useful here. Lim, again, is a very important case. The two most important separation of power cases right now, or actually three, you've got Boilermaker's case, which is the one that set the ground for it early in the 50s for separation of power. But you've got Cable, which we've already mentioned, and Chu Kang Lim as the two biggest separation of power cases that we see right now that are in use. Cable has kind of been eroded into the point of Garrett. And that's just not me talking. That's when Garrett came out last year, there was a lot of anger in the legal community about the decision in Garrett. And hopefully that gets overturned. I've spoken to many people, and the general consensus is that Garrett is unpopular, especially given the fact that you then got to factor in the fact that Garrett was an Aboriginal man. So the justice system is traditionally is seen by many as being geared against Aboriginal people, giving them less consideration to their situation. So you do have to also factor in that as well in overturning Garrett. But we are looking towards seeing the court move towards separation of powers more than we are to parliamentary sovereignty. Although, as I mentioned earlier, when I did this the last time with Aiden, I said, yeah, we're going to see Justice Steward dissent because parliamentary sovereignty. In reality, we saw Edelman dissent, and Steward joined part of the court majority alongside Gagler and Gordon. So take what I'm saying with a grain of salt here, that I could be wrong, given the fact that I said Steward would dissent, and we're now seeing unanimous judgment, with the exception of Edelman having his own little, by the way, aside.
Yeah, I think what I do think is it's hard to predict these sort of things. In some ways, you could argue that they do contradict itself, because you talk about Stewart and the fact that he agreed with the majority despite being a major supporter of parliamentary sovereignty. And you did talk about the whole Lim versus Chapter 3 debate and which one should we be relying upon more. I don't want to speculate too much, but perhaps in Steward's sort of, well, you don't know his exact reasoning or his thought process behind it, but if we do see, which we did see in the case, a lot of reference to Lim opposed to Chapter 3, it's a bit more of a case law focus, though Lim does involve separation of powers rather than the whole proponent of separation of powers being Chapter 3. It's more of the case, the precedent set in the case, which you could definitely see why Steward would support that more than I suppose the founding thought process behind the separation of powers in Chapter 3. So it's hard to predict, as you mentioned, what not only future governments are going to do, but what the courts will judge in terms of the laws being passed, whether they'll be proportionate. There's obviously the Edelman, the proportionality test will play a big part in it, but at what point does it take in the parliamentary sovereignty versus separation of powers debate? And what are we relying upon to base these arguments that we make? Are we relying on case law, or are we relying on a constitutional mandate? And if we're relying on case law, well, it's hard to say, we say cable's being eroded and we reference Garland, and it's very true. It's that in itself is by definition enhancing parliamentary sovereignty. But then we see Ben Breer and NZYQ sort of take away from that, which is why I do say that in some ways it contradicts itself, or not contradicts itself, but the different cases and the different judgments in different cases, whilst legally you could say, they've got their own reasons and they fit certain bounds and certain means, where they fit into the wider parliamentary sovereignty versus separation of powers debates, they do sort of have opposite interpretations in terms of what you can sit back and go, well, this means that the court is going to follow a line of separation of powers or parliamentary sovereignty in the future. If future laws come up, they will, be more likely to judge in this way. And it's really hard to do that when we sort of have opposing and contradicting views, with Stewart especially, right? Being a massive supporter of parliamentary sovereignty in Garrett, and then agreeing with the majority in NZYQ. It makes it difficult. You can make predictions, and people like you and scholars smarter than me will make predictions. But in terms of actually knowing where different individual justices and where the court as a whole will rule on these things, it's definitely not easy to do. And it's why we may not know until the laws do get challenged, if they get challenged. And in that case, we'll have to see what happens.
I've been Stuart Jeffrey. This is Aidan Edgecombe, and thank you for watching.